this. And go on page 140. Okay, let's take a quick vote. I'm pretty sure we left off on this page. Does this sound correct? Which is basically the top of page 11. Okay, well, this is where I'm going to go ahead and get started. If we do backtrack a little bit, then we'll go quickly. But I think this is where we had left off. So I got to do a better job. I keep putting these place markers here, time for a break, and when we finish, I need to put this place marker that says it's time for a break. So that's where I know where to start the following week. But so let's carry on. So we basically are near the top of page 11. We will definitely finish the 16-page RPA today, and depending upon how far we get, we will continue on, and then we'll start just knocking down disclosures and moving on from there. So, but the RPA portion will be done today. So demand to close escrow. And again, I think we might have touched base on this a little bit. My memory is, but nothing like a little refresher. The one thing I love about the notice to perform is, remember, we got that trigger. We got the 2 days and we've got the 2 days. With the demand to close, the default is the 3 days and the 3 days. So a couple of things to keep in mind. And I get this question far too often, but generally speaking, is there's a problem, you're the listing agent, and for whatever reason, the buyer's not performing, at what point can we basically deliver a demand to close? Well, if you haven't already done a notice to perform, then you may be, not always, but you may be premature on a demand to close. So generally speaking, if the actual scheduled close of escrow date is, let's say it's a week from now, okay, too soon to do a demand to close. If they haven't removed contingencies, or you're waiting on the buyer to get a loan approval, or whatever it happens to be, you want to do the notice to perform first and stick within that 2 day window. So don't give them a notice to perform more than 2 days before the trigger is due. And then when you do give them the notice to perform, you're giving them 2 days to basically perform. So on the think of the demand to close in very similar ways. Okay. So the key in here is the seller can give the other party at least 3 days after close of escrow, and actually, I apologize, I got ahead of myself. 3 days to deliver 3 days before close of escrow. So don't give them a demand to close more than 3 days before escrow is supposed to close. Okay. That is going to be the important part of this. So that's laid out in here. A demand to close escrow may not be delivered any earlier than 3 days prior to the scheduled performance date. So the scheduled performance date basically is the close of escrow. Okay. And then you basically got to give them 3 days after that. So just remember the 3 and 3, and then you're going to be good. If you're doing it before the close of escrow date, and by the way, you can do that, but I think your best practice is going to be, you must have had some sort of communication previously with the buyer's agent. I'm not a big fan of sending notice of performs or demand to close blindly. I think truly, guys, you've got to be in constant communication with the other party, especially if you think you're working towards a solution. I believe the worst thing you could do is if I'm working towards a solution and then I blindside the other agent with a notice to perform or a demand to close, I think people's instincts are to push back on that. Like, oh my gosh, I just got off the phone with Alma. Why is Alma doing this? Alma didn't say anything about sending me a notice to perform or a demand to close. So my tip for you guys, quite honestly, as a best practice is, if I'm on the phone and we're negotiating it and maybe we're getting along and it sounds like we're progressing, but I know I still want to send a notice to close or demand to close or a notice to perform, I'm going to tell the other agent, hey, so just so you know, I know we're working on this. I appreciate that. I feel good about where we are. However, I just want you to know I'm going to be following this up with the following document, whatever that happens to be. So I will tell you, though, very similar. Last week I mentioned I don't see a lot of notice to performs in the file. Quite honestly, the same can be said about demand to close. So when you get to that point where you're obviously you're pushing up on a close of escrow date that you don't feel good about, or in most cases you're after a close of escrow date and you're out of contract, Even in those cases, I'm still not seeing a lot of demand to closes. It just seems like we're kind of flying by the seat of the pants. So use these. They're not only are they effective, they also keep your file in compliance. And I think in the long run, you'll be happier if you do. Okay, effective cancellation on deposits. Again, I mentioned last week, I do remember talking about this ever so briefly. We're going to go through the liquidated damages clause here today, and we'll go through this in a little bit more in depth. So in effect, the paragraph H is in effect saying when a party cancels, there is going to be an impact on the deposit. That deposit may be returned, that may be held by the seller, or if frankly, it may be in dispute. Of course, for those of us that have been doing this for a while, you know the general rule, and the general rule is deposits do not get distributed unless both parties agree. One thing that we briefly touched on is there is this little itty bitty $1,000 penalty, if you will, if either party is not acting in good faith. So be careful. Sometimes you have more times than not, this is a seller, not so much a buyer, but where you have a seller who feels damaged, buyers canceling, they don't like the reason they're canceling, the seller feels they've been tied up for days and weeks, maybe months, and now the buyer's canceling and the seller feels they've been damaged. Well, if the contract's not drafted properly, if the buyer's canceling for contingency reason, and the seller needs to act in good faith, and by acting in good faith, it means that that deposit will be returned to the buyer. And if they can be proven not to be acting in good faith, then there's that $1,000 penalty that could be assessed. Okay, repairs. All right.
A question, please, before you move on.
Go ahead, Mike.
So either party may cancel the contract, correct?
Correct.
But it takes two to cancel escrow, correct?
Correct.
Okay, thank you.
Yep. Yeah, on the escrow side, and maybe a better way to put it, it takes two to cancel escrow and resolve earnest money deposits. Okay, so this is one reason. That's a great question, by the way. So let's back up on that. So we have money in escrow. We have a $10,000 EMD. Everybody knows that the escrow is canceling. There's no question about that. The question is, what's going to happen to that $10,000? That's where those two signatures come into play. All right. So, and it can be problematic, and sometimes it's problematic for different reasons. Sometimes you just have a seller or a buyer, or whoever it is, that's just being difficult and just doesn't want to release the deposit. And in other cases, you have people, I don't know if you guys have ever had this happen, but occasionally you'll have people that disappear. Okay. I've had this happen multiple times where one of the parties, generally it's a buyer, but the buyer has just disappeared in the transaction. We have an open escrow, we have a contract, we have money in escrow, and all of a sudden the buyer's just gone. Well, they went to Mexico. We don't know what happened to them. I'm like, well, we have an open escrow and we have money in escrow. We need to deal with that before we can move forward and resell this property. And again, it's a little bit of a different conversation, but to Mike's question is yes, both parties need to sign specifically to dispose of that money. This is why some escrow companies, and we do this as well, we hesitate on actually opening an escrow until we actually physically have money in hands. And some escrows will specifically say escrow is not opened until we physically have money in hand. So, you know, and in part because they don't want to have to deal with immediate cancellations, which happens, you know, so often, where you get a contract and then, you know, escrow spends all this time drafting escrow instructions. They send them out, and then they only to find out the buyer doesn't want to proceed. The buyer has no intention of putting their money in escrow, and in effect, we've got a ghost escrow. Okay, so let's keep on rolling. Repairs. Okay, repairs, and the key on the repairs is, unless otherwise agreed, the property in effect is going to be sold as is. Nothing is going to be done to the property. It has to be dealt with in advance. If there are repairs that are agreed to, they need to be done prior to close of escrow. This little sentence in here causes a lot of heartburn for people. Repairs to be performed at seller's expense may be performed by the seller. Guys, be very, very careful when you have sellers doing their own repairs. This is one reason that I generally advise against negotiating or asking for repairs as part of your contract. It's not always avoidable. Sometimes you must ask for repairs and get things done prior to close of escrow. But if you can negotiate price and price alone and not throw in things like seller to replace the carpet or seller to repaint the bedroom or seller to repair this or repair that, generally speaking, your life will be easier. Because on occasion, to this point, sometimes the seller agrees to do the repairs, but they do them themselves. And maybe the expectation of what that repair is not the quality that the buyer may be expecting. Quite honestly, even things that are done by professionals, if you can avoid it, stay away from, oh yeah, seller agrees to replace the carpeting prior to close of escrow. Great, seller agrees. Does the color exactly match what the buyer expected? Is the seam in the living room in the place where the buyer would want it in the next place? Again, little things like that can just cause you nothing but heartburn. So again, if you can avoid repairs, if you're going to do repairs, of course, do it in writing. Otherwise, the property is basically sold as is in its present condition. That is the default on all of the contracts, unless agreed otherwise. The property is sold as is in its present condition. Keep in mind, that doesn't preclude the seller from doing disclosures. You can sell as is in present condition, but you must still disclose the known material defects. Just putting the as is in there is not sufficient. Final verification of property condition. This is what we used to call the final walkthrough. It's not a contingency. So you got nice big capital letters here saying it's not a contingency of the sale, meaning if the buyer doesn't do the final walkthrough, then that's fine. You know, they don't have to do the final walkthrough. It certainly is best practice. I certainly recommend, if you are representing the buyer, you strongly encourage the buyer to do their final walkthrough and complete it. But some buyers are like, hey, I'm not available, I can't do it, or I'm not interested in doing it. Fair enough. Document that. Do not substitute yourself in place of the buyer to do the final walkthrough. That's troublesome. So, hey, the buyer's out of the country. Hey, great, I'll go take a look at it for you, and I'll be your agent on the walkthrough. If you're just going to go through and says, yes, there's no broken windows and, you know, and it looks like all the furniture's out, that's fine. But I would be extremely careful to go beyond that. You could run into nothing but trouble with the buyer's expectation. Hey, Lance, how come you didn't point out the crack in the sink? And how come you missed this, or how come you missed that? But again, get your walkthroughs done if you represent the buyer. If you are the listing agent and you're being told that the buyer is not going to be doing a final walkthrough and completing Form VP, get something in writing to that effect. Just send an email over that says, hey, we're getting close, just checking, I haven't received the final verification of property condition, Form VP. Am I going to get it? And if ultimately they reply back that says, hey, no, we're not going to do it, take that email, load it into SkySlope, keep it in the file, so that we know that we are not going to be expecting a final walkthrough on these properties. Okay, proration of property taxes and other items. Okay, guys, this is where, for those of you that have fear of math, you're going to have a little bit of a panic attack right now. Having said that, you don't necessarily have to know the math, but I think you need to have a general understanding of how things are prorated. Okay. I do a whole class on net sheets. If you haven't been to my net sheet class, you probably should attend that, because part of what we talk about is how to figure out prorations for taxes and insurance and interest on mortgages and all the rest of that. But what we're referring to here is property taxes are prorated, meaning, and by the way, let's just take these all together. Property taxes are prorated. Interest on the seller's loan payoff is prorated. Insurance is prorated. Homeowners association dues are prorated. So we've got this big lump of property taxes and other items. So the gist of it is the seller is responsible to pay for all of those items up until the day escrow closes, including the day escrow closes. The buyer is responsible to pick things up the day after escrow closes. So sellers' mortgage payments will be basically paid in prorate. So what's the date today? Today's the 16th of February. So if you're a listing agent and you're figuring out your seller's net, and you want to make sure, by the way, hold on a second. I see a comment. Not sure if you mentioned this, but can you do a final walkthrough on Zoom? You know what? You could. I think that would be dangerous. I mean, if that's your like kind of like your last alternative and you want to do a Zoom or a FaceTime kind of a thing, I think you certainly could. And generally speaking, it's probably better than doing no walkthrough at all. I think we could very quickly come up with some very concerning challenges. You know, you're holding the camera, and did you point the camera of your phone into one corner, or did you go too quickly past the flooring in the bathroom, or whatever it happens to be? So I could see all sorts of challenges with that, Jennifer, where you know, somebody sits back and says, you know, that didn't go as well as we wanted, and you should have pointed the camera at that particular item and you didn't do that. So I'm not going to say don't do it. I'm just going to say, if that's your solution, be very careful with that. And then ideally get somebody else that represents the seller there as well. So let's say you have a husband and wife, and the wife is out of town and the husband's here. Get one of them. They're both out of town. Well, who do you have in town? Where's mom at? Bring mom over. Does that create problems? Certainly could, but ideally get them there in person. Okay, so let's get back to the proration of taxes. So sellers, their mortgage payments are paid in the arrears, meaning today is February 18th, February 16th. If your seller has paid their mortgage for for February 1st, their February 1st payment has been paid. That February 1st payment covers January. Okay. Meaning the seller still owes prorated insurance for the 16 days in February. Okay. That's one reason why these demands are so important. When escrow says, hey, I need a demand, or I don't have the demand on the seller's second trust deed yet. Well, those are the type of things that will hold up escrow, because what that demand is going to say, it's going to say what the prorated interest is. It's going to say how good the payment is. And it's going to tell them how many days into the future that demand is good for. So if you're in an escrow situation where the escrow is saying, hey, I'm waiting for a demand, or I'm waiting for an updated demand, you're not going to be closing escrow until you get that demand in and that updated demand. And one of those reasons is they need to get that proration amount from the lender. Now, escrow will figure out how to prorate the property taxes. They're going to handle that for you. Homeowners associations, in most cases, are the exact opposite of a mortgage. So what I mean by that is the homeowner paid their February 1st mortgage payment. Well, they still are going to owe 16 days of February at close of escrow. But let's suppose they paid their February homeowners association dues also on the 1st. In most cases, the homeowners association dues are like rent. The February 1st payment covers the month of February. So in other words, if we close escrow on the 16th, the seller has now paid for the entire month of February, and they would actually get a credit back at escrow for those unused days. And by the way, this is a great time to do this class. 28 days. I don't think this is a leap year, right? This is just a regular February, 28 days in February. Every single month for proration purposes has 30 days in it. There's no 28 days in February. February for proration purposes has 30 days in it. January does not have 31 days in it. January for prorating purposes has 30 days. So you guys do need to know the math. It's important. Most agents, if I'm being honest, don't know the math. They don't know how to figure it out. They don't know what it is, and they just rely on escrow or other people to handle it for them. You can get by that way, but it's not best practice. So just understand everything gets prorated at close of escrow. And I don't know if there is. Okay, there's a line in here about supplemental property tax bills. You need to be prepared and explain to the buyers and sellers, specifically the buyers, that there will be a supplemental tax bill that's going to be coming to the buyer after close of escrow, and you're going to have to handle that. So in most cases, those in that very last line, tax bills, utility bills isn't normally so much an issue, but tax bills after close of escrow are going to be handled between the buyer and the seller. So what escrow is saying, I don't want anything to do with it. Don't call the title company. If it's unclear who that bill belongs to, buyer and seller have to deal with it specifically, generally that bill is going to come in the form of a supplemental tax bill, and that's going to be paid by the buyer. So if you have not prepared your buyer to receive a supplemental property tax bill after close of escrow, then you're going to get a phone call. And frankly, even if you do prepare your buyer, you're going to get a phone call. The buyer is going to say, what is this? So just understand how to get these taxes prorated and insurance prorated, knowing full well, this is something that escrow is going to ultimately handle, and certainly make sure that your escrow is available to help explain it to your buyers as well. Brokers and agents. So this part kind of identifies us. On the bottom of page 11, this talks about compensation. How are we getting paid? All right. First thing right out of the chute is it basically saying, hey, our compensation is being dealt with in a separate agreement. All right. So we're dealing with this through a listing agreement. This in part, this paragraph G3, this is that new paragraph that we've inserted, which I'm telling you guys, we're not using that right now. So if we go back to page 1 or 2 and we get to paragraph G or 3G3, for our purposes right now, we're not using it, which means we will also not be using SPBB, which is the seller something buyer broker agreement, whatever form that is. So for now, we're not going to be dealing with this. So our compensation is dealt with through the listing agreement, through the MLS, and it's dealt with on a different agreement. This is going to be very interesting to see how this changes over the next 12 months. I think we're going to see some changes to that paragraph 3G3. It may actually be removed from the contract until these lawsuits are settled. But for now, I think quite honestly, these references are just going to be confusing. So just tell your seller, hey, our compensation is based upon the listing agreement. This is what you've agreed to pay. This is how we're going to split that up between the listing office and the selling office. And if you represent the buyer, pretty much the same conversation. This is the deal. My agent compensation representing the buyer is coming through the listing agreement, and it's going to be paid at close of escrow from seller's proceeds. You don't have to worry about it. So that can be a challenging conversations. And I think we've done nothing more than confuse it by adding in this paragraph 3G for the moment. Scope of duty. This is in effect telling the buyers and sellers that, hey, there are certain things that we are licensed to do. And then there are certain things that we are not prepared to do, nor should we be doing. Inspection services. I tell stories about, as you may know, I used to be a termite inspector. I was in the business for 9 months. I got out of the business for 8 months because I was going broke. Went and got licensed for termites. Okay. Now my license is expired, but I know a lot about termites. Okay. So I may have more knowledge about a termite inspection than your average person, because I actually had a license to do that. Many years ago, I went and got a general contractor's license to build houses. I still have a general contractor's license. So when I enter into a transaction, in theory, I could have a higher standard and duty to disclose. For 99% of you agents out there, you don't have that. You're not general contractors. You're not termite people. You're not roofers. You're not septic inspectors. So let's not pretend that we are. And that's in effect what this scope of duty is referring to. We're also not attorneys, and we're not tax people, and we're not surveyors. So all of these things that we kind of go through the system that in effect say, hey, let's stay within the letter of our real estate license, and then let's not. One area where it's really, this happens a lot, and you guys got to be careful of this. I see it happen every day. I probably do it every day, is where, let's go back to that final walkthrough. You do a final walkthrough, you're looking at something, you kind of look at each other and say, it's not that big of a deal. You should be able to get that fixed for, $400 or $500. Everyone kind of looks at each other and says, yeah, that seems pretty reasonable. That's no big deal. We're not going to ask for any repairs. Let's close escrow. And then all of a sudden that $400 or $500 item is much more serious than we thought. It's going to be $4,000. And now you've got a buyer looking at you saying, hey, Lance, you said, you thought it was going to be $400. It's $4,000. Now what are you going to do? So just be careful with that. I don't see anybody unmuted. I'm going to keep on rolling. Joint escrow instructions. This is kind of a joke, to be honest with you. I'm not going to go back to page 1 of the RPA. But if you go back to page 1 of the RPA, it says that this is the residential purchase agreement and joint escrow instructions. The title of the RPA was changed oh my gosh, I don't know. Anybody, any old timers here? Remember how long ago that was? Maybe 20 years ago, maybe. So I'll tell you a way to, if you want to know when you're dealing with a really old real estate agent, is when they call it the contract, the receipt for deposit, because that's what this used to be called, a deposit receipt. So if say, I'm going to send over the deposit receipt, and you're like, what are you talking about? Well, they're going to send over a contract. That's what it was called before they changed the name and added the joint escrow instructions. So this is the irony of it. 30 years ago, 20 years ago, when they made this change, the intent was there was not going to be additional escrow instructions. This contract was also the escrow instructions. And they've never changed the name. They've never changed. They've left it for 20 years. For about 6 months, some escrow companies would accept the contract as the escrow instructions. And what that meant is escrow did not type. You guys know, you get this big old stack of escrow documents and they basically retype almost everything that's in the contract. All they would do is they would put a cover letter on it and say, hey, this is the deal. We accept these as our escrow instructions. This is our escrow instructions. So anyway, they did that for about 6 months. The escrow people said, you know what? Real estate agents don't know how to draft contracts very well. This is a liability. So I don't know of one escrow company who actually will accept the RPA as joint escrow instructions, meaning they type everything all over just like they've done before. So just understand that even though this says joint escrow instructions, in practice, that is not the case. Even though when we get to the last page, there's going to be a spot that the escrow signs, a little bit of a different deal. But bottom line is, even though the title of the form says and joint escrow instructions, let's not kid ourselves. These are not escrow instructions. So this, however, has language in there that says, hey, this is what the escrow is going to do. The escrow is going to follow these instructions. If it says we're going to close on the 15th, escrow's instructions are to close on the 15th, as long as all the parties have provided the documentation. And that, in effect, is what paragraph 19 is saying. There is an acceptance part down on paragraph 19C. That's the very last page, which we're going to get to here in a few minutes. And all that says is escrow is accepting the contract as the escrow instructions. The reality is most escrow companies, not most, they'll sign it, but they're replacing it. They're supplanting the contract with their own set of escrow instructions. It just is what it is. Frankly, it's a little piece of trivia that most of you on this call probably didn't even realize that the whole concept of the title of the contract and joint escrow instructions was to completely replace the escrow instructions. They did it 20 years ago. They never changed the name, and it's kind of a silly thing we have right now. So the reality is, most of you, when you're referring to this, when you're dealing with your buyers and sellers, what you're going to immediately say is this. You're not going to go through the story I just told you. You're going to say you're going to get a separate set of escrow instructions directly from Cobalt Escrow. Those escrow instructions are going to mirror everything we've put in the contract. Let's everybody do a good job to read those. Let's make sure if it says that the seller's paying for the home warranty in the contract, that it says that the seller's paying for the home warranty and the escrow instructions. Let's match all those things up. And then there will be an additional set of documentation for the buyer and seller to sign from escrow. Pop quiz, unmute yourself if you want to play. If not, I'll give you 3 seconds and I'll answer it myself. When you go to court, does the judge give one rip about the escrow instructions, or do they look at the contract? You can probably tell by the way I've asked the question. I don't see anybody unmuted, so I'll play my own game. Escrow instructions very rarely, if ever, will make it into a small claims court case or a superior court case, because escrow instructions are not a contract. Okay, this is the contract. Escrow instructions are exactly what they say. They're instructions to escrow. But wait a minute, Lance, the buyer and seller signed the escrow instructions. That doesn't make them a contract. So point being is, if there is a mistake in the escrow instructions, let's use the example I just used, where the contract says the seller's paying for something, the escrow instructions say the buyer's paying for something. This is not a game of gotcha. The contract prevails. So even if the seller signed the escrow instructions that said that, you know, they were going to pay for something that they weren't, whatever the contract said is what will prevail in this. So you'll never end up in front of a judge having to defend a set of escrow instructions. You may have to defend it in front of a client, Because clients will read it and then they'll be like, oh, well, how come you didn't catch this, Lance? I didn't know that. I just read the escrow instructions and I thought that the seller was going to pay for it. Now you're asking me to pay for it. Okay, I don't see anybody muted. I'm going to keep on going. So we are continuing on into the escrow sections. The top paragraph D talks about agents are not party to the escrow. Okay, we're not buyers, we're not sellers. We have nothing to do with the escrow. Our only involvement in the escrow, in effect, is how is the compensation going to get dealt with? One thing with escrow, and this is a best practice item as well. Let's suppose Jennifer and I are in escrow together and we're talking and we're like, hey, you know what, we've been going around and forth with these repairs and we agree that the seller is going to credit the buyer $2,000 for repairs. But we've agreed that, we've verbally done it. Now I call escrow or Jennifer calls escrow and says, hey, please draft an amendment that says that the seller is going to pay $2,000 for repairs. Most escrow companies will not take those instructions from the agent without some sort of backup. Okay, why won't they do that? Well, they won't do that because you're not a party to the escrow, and what you've asked them to do is contrary to what their current instructions are. Their current instructions say nobody's paying for any repairs. So what escrow is going to want to see is they're going to want to see an amendment to the contract signed by both parties that says, hey, seller agrees to credit buyer $2,000 for the following things. Buyer signs it, seller signs it. You now deliver that to escrow and says, hey, we've amended the contract. Here's the amendment. Would you now please amend the escrow instructions? Okay. Then the escrow will draft an amendment. Both parties still need to sign it. Escrow is not going to move forward with that $2,000 change. Even if they've signed the contract addendum, but they haven't signed the escrow amendment, escrow is going to say, I can't do this until both parties sign. One of the reasons escrows don't like doing that, they don't like drafting amendments that not everybody's agreed to, because now you got this amendment floating around there that's problematic. So again, we're not party to the transaction. Buyer and seller acknowledge that escrow holder may require invoices for expenses on the agreement. So if there's going to be something that's going to get paid, you better get it into escrow. It's asking for those items within a few days prior to close of escrow. And pretty straightforward stuff. Not a whole lot to go over there. Upon receipt, escrow holder shall provide buyer and seller each verification of buyer's deposit. So this is that receipt. The buyer put in their $10,000. But escrow is now going to show evidence of that. Why is that important? Because it's part of the contract. It's part of paragraph 5A1 or 5A2. Escrow holder needs to be able to do that. A copy of an amendment that affects the paragraph of this agreement for which escrow holder is responsible shall be delivered to the escrow holder within 3 days. That's exactly what we just referred to. So if the buyer and seller amend the contract, that amendment needs to get into escrow within 3 days of execution of that amendment. Hey, we just agreed to do a $2,000 credit. Get a copy of that into the escrow so they've got that in their file. Okay, I don't see anybody unmuted. We're going to keep on going. Selection of services. This is, hey, we're going to use Cobalt Escrow. We're going to use Orange Coast Title. We're going to use First American Home Warranty, whatever it happens to be. This in effect is saying that ultimately at the end of the day, the buyers and the sellers choose services. As a general rule, we recommend all the time, but then at the same time, it's like, hey, here's 3 companies to choose from. The reality is most buyers and sellers don't have any experience with this. They're going to trust us. They're going to say, hey, yes, can you get me to an escrow company that you have experience with, a title company you have experience with? Who have you had good luck with on a home warranty? We do make kind of big deals about this selection of services and we get all exercised. Oh, we got to give them 3 copies and 3 choices. The reality is I've never had any even close to litigation where a buyer came back and said, you referred to me ABC Home Warranty Company and they're terrible. I'm going to sue you. I've just never seen that happen. But again, this in effect is telling the buyers and the sellers that they have the ability to choose their services and they can negotiate that if they want. A multiple listing service. This is more of a disclosure that's in the contract. And in fact, this is just telling all parties that the property is in the MLS and that the agents are authorized to put this information into the MLS. So there's going to be things like, this is when it closed, this is what the price is, there's going to be photographs on the property. If you do this business long enough, you will close escrow. And somebody, normally it's the buyer, will call you after close of escrow and say, hey, take all those pictures off the internet. I don't want people looking at my house. It's my house now. Well, good luck. It's just, it's the internet. It's never going to come off. Yeah, but there's a floor plan and it shows where my kid's bedroom is. It's the internet. You just can't get those things off. So this in effect is telling the buyers and the sellers that once it goes into the MLS, all this information is out there. I got to tell you, nobody complains about this anymore, but back in the day, this was a huge deal. People were just so uncomfortable with the amount of information that was available online, whether it was security concerns or whatever. Now I just think we just kind of understand that's just how it is. But that's what this paragraph is referring to, that information is going to be public and it's pretty much going to be out there forever. Attorney fees and costs, I will explain this to you the same way I would a buyer and seller. It's a very short little paragraph, but it's an important paragraph. And what this in effect says is, if there's any action associated with this contract, the prevailing party is entitled to reasonable attorney's fees. So I'm in escrow, buyer and seller, they end up fighting over something. The buyer wins, the buyer is entitled to compensation from the seller to cover attorney's fees, et cetera, et cetera, et cetera. So this is the exact same language that's in the listing agreement and pretty much the exact same language that's in almost every single contract that you guys are ever going to sign. So pretty sure, I do find it funny. The attorneys, of course, wrote this and they literally were able to do it in one sentence. Whereas everything else seems to take a few more words, but the attorneys got that part figured out. Assignment and nomination. If I'm not mistaken, we kind of covered this when we were earlier in one of the classes. I can't remember. This is where I got to kind of go through and do a little self-audit on these classes. But what are we talking about here? And this is that part that I said potentially could be misunderstood. Buyer shall have the right, let's read it. Buyer shall have the right to assign all of the buyer's interest in the agreement to buyer's own trust or any wholly owned entity of the buyer that is in existence at the time of this agreement, period. So what does that say? Okay, I'm Lance Martin. I have a trust called the Martin Trust dated July 10th, whatever, 1995. Okay, I own that trust. It's that trust was in existence before this agreement. By contract, I can assign Lance Martin's interest in this contract to the trust that I own, period. Don't need the buyer's or seller's permission. I got it. I also own a corporate entity, DLD Partners Incorporated. I am the owner of that entity. That entity was in existence at the time this contract was drafted. This sentence basically says I can do that. Now, if I created that entity or that trust after the date of this contract, I do not have the exclusive right to assign it into that newly created trust or that newly created LLC or corporation. Doesn't mean I can't do it. It just now means I need to ask the permission of the seller that says, hey, I'd like to do this. And in most cases, sellers are going to be fine. But this is that full stop on the period. Okay. So then we have otherwise, buyer shall not assign any or part of the interest in this agreement without first having obtained a separate consent of the seller, period. So now the seller has to agree. Okay. But this is where, no, wait a minute. The seller cannot unreasonably withhold consent. So would it be unreasonable for the seller to say, hey, Lance, no, I'm not going to let you transfer it into the trust because you just created it. Just it's a living trust. What's the big deal? It's not going to hurt you at all. That would be, in my opinion, it would be unreasonable for the seller to withhold that approval. But there's all sorts of other examples. I don't know if Myra's on the call today, but Myra and I don't see her. We talked about this. We might have even talked about this in a prior contract college where she has an investor client and that investor client likes to assign their contracts. They're assigned to third party peoples more than arm's length. They're not part of their trust. If I'm the listing agent, I'm advising my seller, no, well, we might approve it, but we want to do some due diligence. We want to take a look at it. We want to make sure that we're just not willy-nilly assigning this to some third-party straw buyer. So again, we did talk about this in an earlier class. I think it's pretty clear. Just read those first 2 or 3 sentences, because this gets confusing. People, specifically buyers and or their agents, all they do is they just look at paragraph 23 and it says the buyer shall have the right to assign buyer's interest, and they just stop right there. It's like, yeah, I can do it. Okay, well, there is some caveats. Okay, I don't see anybody unmuted, and I am looking at the unmute, guys. So if you have a question, just unmute and I'll see you. So if I don't see that, I'm just going to keep on rolling. Okay, equal housing opportunity. We sell the property to anybody as long as they can qualify, they have the money. We do not discriminate, period, full stop. Pretty straightforward stuff. Okay, jumping to the top of page 16. This is the definitions clause. Quite honestly, you guys need to read this. I get this all the time. And sometimes, honestly, I got to go back and read it myself, specifically when it talks about things like days. So let's go through this. Acceptance. Acceptance means the time the offer or the final counter offer was fully executed. Boom, in writing. Oh, by the way, and delivered. So what's that date? So maybe the date up here is February 10th, but the fully executed contract wasn't done until February 15th. Then the date of acceptance is February 15th, all right? But also has to be delivered to the other party. So if they accepted it on the 15th, but they didn't deliver until the 16th, which could be tricky, okay? So acceptance is the fully executed contract and delivery, okay? Agent, that's you guys. We use broker, salesperson, broker, associate interchangeably. So we are all the agent in the contract, in the agreement. The agreement means this document. It's funny, I used to, I haven't said this in a long time. I would prefer, back on page 1, they use the word contract. This is a contract as opposed to the RPA, the residential purchase agreement. That was done consciously. That was done because people will sign agreements. People are more hesitant to sign contracts. Make no mistake about it. The purchase agreement is a contract. Okay, but we don't call it that here. We call it agreement. This goes way back, and some salesperson somewhere said, let's not call it a contract, let's call it an agreement. People will sign those a little bit more readily. Seems a little silly, but that's what it is. As is condition. Okay, we've talked about this multiple times in our contract college. Okay, property sold as is does not preclude the seller from disclosing known material defects. In next contract college, I've been meaning to do this. Maybe Drew can find it and we'll get a good laugh out of it. And Drew and I I think Drew and I were working together at the time. We sold a property. This house was not even a house. Okay. Had liens on it. There was trees growing inside the house, holes in the roof, dirt. You could literally, you walk in the house and you saw dirt. You look through a wall and you'd see outside. We sold it as is. Okay. You can sell a house as is. You just have to disclose all of those defects within the property. Authorized agent. Who is the authorized agent? Means the individual real estate licensee specified under the real estate broker section. So I'm authorized, or I'm looking at Jennifer's headshot here in front of me. Also just use Jennifer is an agent of Coldwell Banker Town and Country. She is the authorized agent at Coldwell Banker to act on behalf of Coldwell Banker to execute or to move forward with this agreement. That's what we're referring to. CAR forms. By the way, try not to use that acronym in front of your clients. They don't understand that. You say, oh yeah, we use a CAR form or CAR forms. If you use that, I just did that today. I realized the person I was talking to had no idea what I was referring to. Oh, we're going to use the California Association of Realtors Purchase Agreement. And take a minute to explain to them, hey, this is drafted by our trade association, the California Association of Realtors. It's a consumer-friendly form, et cetera, et cetera. Be careful on the acronyms, guys. People get scared when you start throwing around COE, for example. We know COE means close of escrow. When you start using that acronym with your buyers and sellers, don't just assume they understand what that means. You're going to create a sense of uncertainty and fear. So let them know, close of escrow. This is what it means. By the way, what does it mean? It means the date that the grant deed is recorded, period. Okay, not the date on the contract necessarily. Copy. Yes, we can have photocopies. Yes, a fax copy is sufficient. Yes, a PDF sent via email electronically is sufficient. So all of those things will work on our definitions. Counting of the days. This is a silly one. Okay. When do we count days? Counting days is done as follows, unless otherwise agreed. So what do we do when we count days? The first day after the event of the full calendar date. So if it's going to be possession be delivered 3 days after close of escrow, well, if we close today, we don't count today, the first day after. So that would be, let's say Thursday, Friday, Saturday, Sunday. So if that's our example, we don't count the day where the event is triggered. All right, so it's going to be, yeah, that's how we count them. So again, I guess they use this example of a 0 day. So today would be day 0. If we close escrow today, today's day 0. So if 3 days after, tomorrow is day 1, the next day is day 2, the next day is day 3. Days or days, meaning calendar days or days. However, delivery of the deposit of escrow is based upon business days. Oh my gosh, what does that mean? Well, it depends. Okay, if it says calendar days, it means calendar days. That includes Saturday, Sunday. If it says business days, we don't count Saturday, Sunday. We don't count holidays. Keep that in mind. Sometimes that'll come back and bite you a little bit, depending upon what you're looking at. Delivery, again, what's delivery? Delivery is I've got a contract. It's not fully accepted until it's delivered back to the other party. How can I deliver that? Can I deliver it electronically? Could I have to deliver it in person? Whatever the document calls for. We're going to talk about this a little bit when we get to the last page of the contract. It'll be a little bit more clear on what we're referring to when it comes to delivery. Electronic copy, again, used to be a big deal. Now I go through all the SkySlope stuff. I am shocked at the high percentage of contracts and disclosures that are fully executed electronically. That used to be a small percentage. Then I'd say, I don't know, even 4 or 5 years ago, it was probably 50%. Now that number is above 90%. Above 90% of everything I'm seeing is signed electronically, fully signed by both parties. That's a beautiful thing. The law means exactly what it is, the law, code, statute. Legal authorized signer, again, whoever is the authorized entity. We'll talk about this. So when you use this term, normally when we're referring to a trust, who's the trustee, the legally authorized signer of the trustee, the legal authorized signer for the corporation. And then of course we use that form as called for, and we're going to get to that here in just a few minutes. We're going to be on that page. Unless otherwise agreed means, again, it means exactly what it says. The contract says this, unless otherwise agreed somewhere else. What would that mean? Well, this is what it says in the contract. It says the sales price is $400,000, unless it's countered somewhere else to $395, otherwise agreed. So whatever you're going to change, there's a lot of defaults in the agreement. We change those defaults all the time. Every time we change the default with a counter offer or an addendum, we are agreeing otherwise. And that's pretty much what we're talking about. Repairs means any repairs, anything done to the property. I find it interesting that they said including pest control. I don't know who thought that was important to put in there, but I mean, you could have said including pest control, including roof, including septic. I don't know why pest control got to such a prominent mention here, but anything that's done to the property under the agreement is repairs. Signed or signed means exactly that. The property, it has been signed either by hand or by electronic signature, or by counterpart. Okay, counterpart just means that you've got let's say it's a husband and wife. They're not in the same room. One of them's out of the country. The wife signs in person. We have a signed copy from her. The husband signs electronically. You put the two together, which you really don't put the two together, because the one that the wife signed does not have the husband's signature on it. The one that the husband signed does not have the wife's signature on it. Put them together, they are a counterpart, perfectly legal, perfectly binding. You do not have to have all the signatures on the same physical piece of paper. A lot of agents get hung up by that because it just doesn't look clean. You look at once, oh my God, this is not fully executed. What's going on? Well, it's not fully executed because you don't have the counterpart. You need to get the other part. And then once you have the two parts together, you have a fully agreed upon contract. Terms and conditions of the offer. This in effect says, hey, This is it, okay? These are the terms, these are the conditions. There's nothing else going on here. This is the agreement. Pretty straightforward stuff. Time is of the essence. It in effect says, if it says to do it in 10 days, do it in 10 days. If it says to deliver the document within 7 days, deliver it within 7. If it says to remove contingencies within 17, do it within 17, or be prepared to deal with whatever may come out of that. There's a section here talking about an extending or modifying. Another, if I'm being honest, one of the concern, and I love, you guys are doing a great job in SkySlope, but I mentioned earlier, I don't see enough notice to performs. I don't see enough demand to closes. I think there probably should be more. But what I also regularly am not seeing is escrows that the close of escrow date is passed and there has not been an extension of terms. Okay, guys, that is super, super dangerous. So make sure that you are extending these contracts, making those changes in writing and getting those things handled. Once you get out of contract, bad things can happen. Okay, let's get to the top of page 14. Who is the legally authorized signer? So again, generally what we're referring to here are corporate documents. Who is the representative capacity for the corporation, for the trust, whatever it happens to be? We need the legal authorized signer to basically sign the agreement. Okay. And by the way, we always say that that's for a trust or that's for a corporation, but let's just suppose it's not. It's like it's Lance and Julie Martin, husband and wife. Okay, well, then the legally authorized signer, whoever's on title, my kid does not sign for me unless there's some other documentation that says, hey, I've given him a power of attorney, or there's I'm in a conservatorship, or I've got some sort of diminished capacity, somebody else is helping me. So it doesn't always have to be a trust or a corporate entity. It could be just a normal entity, but then a power of attorney or something would come into play. I gotta tell you guys, I always get nervous when someone says, oh yeah, and Sally has a power of attorney. Someone just called me with that. Says they have 7 people on title to the house they're selling. 3 of them are in Mexico, and 1 of them has power of attorney for those 3 people. Okay, can that be done? Okay, sure, but first person you need to call probably is not me. You got to get a hold of the title company and say, hey, how do you feel about this? How do you feel about Sally Smith has power of attorney for these 3 people who are out of the country? As long as title says cool, then we're good to go. Otherwise, be careful. Liquidated damages. Okay, we're back to liquidated damage. I keep referring to this paragraph. This part of the contract to me is out of order. When we were back here, I'm going to go back for a second. When we were way back here, whatever page this is on, talking about demand to close and effects of cancellation on the deposits, it seems to me that this paragraph H needs to come back over here and tie back in to the liquidated damages clause, because they truly go hand in hand. They refer to the same thing, and we're like 3 pages down the road. Honestly, I think they need to put the liquidated damages clause on page 1 of the agreement, right underneath where the earnest money deposit section is, because it truly deals with that. So what is liquidated damages? Liquidated damages basically is a legal term that says the buyer and seller have already agreed, that if this contract goes sideways, we've agreed on what the damages are. Okay, so for whatever, if the buyers and sellers are initialing liquidated damages, generally speaking, in 95% of the time, we're referring to the buyer's damage, the buyer's in breach of contract. The buyer should have closed, but they didn't close. The buyer's gone crazy at the last minute. Okay, this basically says the damages are limited to the actual deposit, 10 grand. Okay, whatever the actual deposit is, or a number not to exceed 3% of the purchase price. So if we have a $1 million transaction, the maximum damages, 3% of $1 million, $30,000. Those are the most that the damages can be. However, But if the earnest money deposit on that $1 million transaction is only $5,000, then the maximum damages that the seller can expect to get on that is the actual deposit paid, $5,000. Now I have a reverse story on this. I'll do it really quickly. I represented a transaction, a buddy of mine years and years ago, and I frankly was trying to flex a little bit. And I said, hey, I've never written a contract with a huge deposit. I know this client had the ability to do a huge deposit. So I encouraged them to put down $100,000 deposit. I think the property value, I think it was $1 million or $1.5 million or something like that. And let's just say it was $1 million. We'll keep the math simple. So I encouraged the buyer to put a $100,000 deposit down. Now, granted, I did think it made the offer look stronger, and I thought it was going to give them a better opportunity to get the offer accepted. Well, lo and behold, it did get accepted. But what I wasn't expecting was that my buyer was going to cancel 3 days later. Okay. And reality was they canceled for nonsense. They just changed their mind. Well, we had $100,000 deposit in on that escrow, and the money was in escrow, put it in escrow. And the maximum in damages the seller could have received on that deal, the maximum was 30 grand, but we had 100 grand at risk. Okay. So ultimately we went back and forth, and I lost a lot of sleep over it. The seller, after holding us hostage for a week or 10 days, did sign, released the entire $100,000 earnest money deposit. But my recommendation to you guys is, frankly, my recommendation is get 3% earnest money deposits from your buyers. If you're the listing agent and you can get them to put more than 3%, good on you. But generally shoot for that 3% number. If you're a buyer's agent, certainly don't put more than a 3% EMD in. And just keep in mind, whatever that amount is, you need to turn to your buyer and say, this money's at risk. Okay, this money is at risk. If you cancel on the seller and you are going to go to battle, that's the amount of money that's going to get held aside. And again, buyers and sellers do need to initial off on these for this to be part of the contract. Mediation is built in. Okay, parties agree to mediate. There's no initial on this. It says I'm agreeing to mediate. So if there is a problem before they do anything else, it doesn't mean they can't go get an attorney and write a letter and threaten to sue you and all the rest of that sort of stuff. But at the end of the day, it's like, okay, fine, we can't agree, we're mediating. So that's basically what paragraph 30 is referring to. Every party agrees to mediate, period. After you get through the mediation side, then we get into the arbitration section. Now, the reality is, guys, and I've been through a lot of these, 99.9% of the time when you're going to mediate, that's it. Okay, you just go through the mediation. Parties, I'm going to skip ahead here. There is a section here for arbitration. That section does need to be initialed by both parties for the arbitration to be valid. Now, the basic difference, okay? Mediation is required, but not binding, okay? You can go mediate, you say, screw that, I don't agree with the mediation. I now want to I want to sue them, or I want to go to arbitration. The arbitration side, if you agree to arbitration, and if you did agree to arbitration, generally speaking, you skip mediation, you go straight to arbitration. Why? Because arbitration is binding. Whatever the arbitrator says, this is what you're going to agree to. Okay. So again, I'm not going to go through and read this entire language, but the gist of it is all the contracts have mediation. Most of the time it's good enough. The truth be told, I mean, done far too many of these. They drive me crazy. And again, we get to bring up Norm at this time. And one of some of the best times I've had with Norm, to be honest with you, were during some of the worst times we had, like at a company level, because at a company level, trust me, we don't like getting sued. We don't like having clients that are unhappy, whether we're involved or not, or whether we're just witnesses. We don't like that. Having said that, Norm and I had some pretty good times, you know, laughing and crying through mediations and arbitrations. Having said that, I'm going to say 99% of all of these clients that are going back and forth, I'm going to sue them, I'm going to do this, screw that, never go to mediation, arbitration, or anything past just a lot of bluster. All right. The ones that do ultimately get there, 99% of the time, they stop there, meaning that there's no additional litigation. You don't go 2 years to court on these transactions. Whatever the result of the mediation arbitration is, people generally will accept that. And the reason they do is it's just super, super expensive to litigate. I mean, the reality is, guys, we sell median price homes in California, 2, 3, 4, 5, 6, 7, 800,000, 900,000. Maybe on occasion we get $1 million, $2 million. Even the $1 million, $2 million sales, it's so expensive to litigate on those transactions. It generally doesn't go there. The ones that go there are the $30 million property in Malibu. Those buyers and sellers get upset with each other. Sure, they'll go 2 years, they'll spend $300,000 on attorney's fees to litigate it out. Your average buyer or seller is not going to spend. I've been involved in cases that have gone to trial. You can't go anywhere for 100 grand per side, 100,000 bucks, period. And nobody's going to be happy spending 100 grand on a $500,000 purchase price. It just doesn't happen. So mediation's mandatory. Arbitration is voluntary. I do recommend that the buyers and sellers sign the arbitration clause. At the end of the day, it is a better way to go than it is to just go straight into court. I don't see anybody unmuted. We could do a 3-hour thing on mediation arbitration, guys. I know I did an abbreviated version of that, but unless you've got any questions, I'm going to keep on marching on. Okay, so we're kind of getting there. We're almost there. So buyer's expiration. So we're getting ready to have the buyer sign our contract. Okay. So first thing we talk about before we get to that buyer's signature is, when does the contract expire? Expiration of the offer. This offer shall be deemed revoked. And the deposit, if any, what they mean by there is the deposit's probably still sitting in the buyer's account. Okay. And deposit returned to the buyer, if any, unless the date and time specified in paragraph 3C of the offer, and we're going to get to that in a minute, and a copy of the signed offer is delivered, there's that word delivery, to the buyer or the buyer's authorized agent. Okay. By the way, it's also telling the buyer, this is a note to the buyer, by the way, seller has no obligation to even respond to the offer. So first part of expiration says, hey, my offer does not last forever. My offer generally is going to expire at a certain date and time in paragraph 3C, which we're going to get to in a minute. So everybody needs to understand that time is of the essence. Also, Mr. and Mrs. Buyer, understand the seller does not even have to respond to your offer. We can basically ignore it. Not best practice, but they can ignore it. So we'll get more on that date. Very important in a minute. Entity buyers. Entity buyers is basically the trust, the corporate entities, whatever it happens to be. If you are an entity buyer, then you're going to check the box, and then we're going to identify what type of entity you are. Okay, so one or more of the buyers is a trust, corporation, and LLC. So there's one power of attorney. Okay, so we're an entity. Number two, the agreement is being signed by the legally authorized signer. Okay, so somebody is authorized to sign for that entity. What is the name of the legally authorized signer? The name is Lance Martin. Okay. By the way, the entity, the buyer, going back to page 1, it's going to say DLD Partners. That's the entity. Okay. I would check the box as DLD Partners or the Martin Trust, dated, whatever. That's the entity. And what is the name of the authorized signer? Authorized signer is Lance Martin. That's the person signing the document. If it's a trust, the identity buyer is the trustee of the trust, or a simplified text, you can put John Doe, trustee, whatever it happens. So what they're referring to there is, let's go back and read that again. If a trust, identify buyer as trustee of the trust, or by simplified trust name. So for example, John Doe, trustee or code. So in other words, what they're saying there is you don't have to sit back and say John Doe, trustee for the John Doe Family Trust, dated January 5th, 2015. You know, we've had these gigantic, super long names. It's been very, very difficult. So this language here is in effect saying we can use the simplified name. Okay. John Doe, trustee, or the Doe revocable trust. You don't have to go crazy and put all that extra stuff in there. And this is a nice, people still get confused on this. Sometimes I get confused on this when I explain it. But if you're in that situation, just realize you can use the simplified name and it's still going to be legally binding. If the entity is a trust or a probate, if there's any sort of court case associated with it, what's the case number? Okay, put the case number. Maybe maybe there's a divorce. This is being done by a court order, whatever that case number is, and then make sure you have that order handy, because that order is going to basically tell you what you can and cannot do. I just talked to Gil Pacheco yesterday in Claremont. He's been assigned the signing authority for, I believe it's, not really sure what the legal case is, but anyway, he has a court document that says this is what you're doing and you're in charge. So all that documentation needs to be in there. The RPA has 16 pages. Buyer acknowledges a receipt and has read and understands all of them. Fair enough, pretty straightforward. Now, where are we? We've got buyer's signature. Buyer's going to sign. Okay, so we've got Lance Martin, printed Lance Martin. Again, if this is a legal authorized signer, I'm going to check the box, name of legal authorized signer. So this could be Lance Martin, or excuse me, this could be DLD Partners. And what's the name of the authorized signer? Well, the authorized signer is Lance Martin. All right. If you have multiple buyers, you have multiple lines associated to use that. And again, if you have more than 2 signers, this is a lovely thing. Then we're going to use the additional signature addendum. So buyer number 1 will sign, buyer number 2 will sign, then we'll click additional signatures. And I believe the additional signature addendum has space for another 5 signers, if I'm not mistaken, maybe 4. So pretty straightforward stuff. Buyer signature there. Acceptance. Now the seller has an opportunity here to accept the offer. So acceptance of the offer. Seller warrants number 1, hey, I own the property. Seller says, I'm authorized to execute the offer. Okay. Pretty straightforward. So let's just skip ahead. If the seller signs the contract and none of this stuff is checked, contract is accepted as is, done. Let's skip ahead here. So just go straight to the seller's signature. If the seller signs and nothing up here is checked, terms and conditions are accepted, no changes, boom, done. Okay. Or seller has a couple of opportunities here. What sort of opportunity does the seller have to do? Seller can sit back and check the box that says, I'm giving you a counteroffer, the SCO, or a seller multiple counteroffer, the SMCO. In that case, you will check this box. I want to counter this offer. Okay. So I'm checking box 33A, seller counteroffer. I'm still signing down here. Okay, so what you're doing is when we get to the counteroffer part, you're saying, I accept everything on the 16-page contract except the items that I've listed on seller counter. Okay, I have agents that are reasonably experienced, and then occasionally they'll call and say, hey, I sent out this counter, but should I have the seller sign the original offer? I'm like, yes, you have no counteroffer unless the original counteroffer has been executed. Okay, your counteroffer in effect is not valid unless the seller has signed the original 16-page offer. If you are representing the seller and the seller is going to be using this offer as a backup, then you're going to issue the backup offer addendum. Okay, and we'll get to these counter offers and these backup offers and what those mean as we move forward. Under the seller entity, very similar to what we just looked at under the buyer entity. So now the seller is a trust, or the seller is a corporation, or the seller has some sort of legally authorized signer. If that's the case, you're going to check paragraph B. We're going to go through and basically go through the exact same questions that we looked at on the buyer side. What are they? What's the name of the signer? Can we use this simplified name? And if there's anything to do with a court order, put in the court order. This language is identical on the buy side. So once you've got one side figured out, you're just going to apply it to the other side of the transaction. Easy peasy. Again, now we're telling the seller, this is a 16-page agreement. You've acknowledged a receipt and you've understand it and you've received copies of all of those. Seller now gets to sign here exactly the same way. as the buyer signs. So they will sign, they will print their name, and then again, printed name, a legally authorized signer, whatever. Maybe they're a trust. Like on a corporate entity, you might see things like president, secretary, director, that sort of things, whatever their title is on those entities. So they would sign, just like on the buy side. Hey, I've got 4 sellers, not just 2. You're going to check the additional signature addendum, and away you go. Offers not accepted. Now, I will tell you, this is very, very rarely used. Quite honestly, I think, Drew and I pretty much exclusively do work with sellers for the most part. Not that we don't work with buyers, but for the most part, we work with sellers. Unless the buyer's agent asks us for this, and Drew can chime in if I'm wrong, because he normally does this. I generally am not issuing these, okay? But if the buyer's agent says, hey, I want to make sure, send me over that my offer is not accepted, respond to my offer. Okay, fine, great. Offer is not accepted, seller initials there, no counter offers are being made. Offer was not accepted by the seller on this particular date and time. All right, I'm not, a lot of buyers feel that there's shenanigans going on and their offer wasn't presented or whatever it happens to be. So this
Not once have I ever used it. I've
Yeah.
had probably 30 people ask me for it, and I don't think I've ever gotten it actually signed by the seller and given it to them.
There you go. Well, you see what a mean listing agent. Not only does it not provide it, he doesn't even provide it when it's asked for. So I would suggest, guys, if you do have somebody asking you for it, put in the extra effort and get it to them, but it's certainly not required. But again, it is one of those things that's in the contract. Generally, it's just kind of, okay, whatever. We didn't get an offer accepted. Let's move on to the next. And frankly, when you do have people that are asking for this, you've either got agents with far too much time on their hands, or frankly, they really think you haven't presented their offer. They really think that you've probably done something inappropriate. We get that on the high volume stuff and do a lot of foreclosures or work at the hedge funds. You tend to develop a reputation with some agents that, we don't care, we're not interested, which is nothing further from the truth, because we want to do it as correctly as anybody, even more correctly, because, what one misnomer about a lot of foreclosure agents, especially the good ones, is, oh, they get fast and loose and, blah, blah, blah. I'm like, just the opposite. Those guys, we run a tight ship. Why do we run a tight ship? For all, number one, because it's the right thing to do, but we run a tight ship because we want to keep that account with Fannie Mae. We want to keep that account with Freddie Mac. We want to, if you got people complaining all the time that you're doing a bad job, it's hard to keep those accounts. But anyway, to Drew's point, it's very rarely used, if ever. And there's another one here we're going to get to in a minute. This is the broker section. So we're now at the top of page 16, right? Hold on a minute. It's the bottom of page 15 is where the seller signs. Now we're on the last page, top of page 16, real estate broker section. Agents are not parties to the contract. Fair enough. The agency relationship has been confirmed in paragraph 2. I represent the seller. You represent the buyer. Cooperating brokers compensation is dealt with in a separate agreement. We've got that covered. So we now know how we're going to get paid. Very easy, very nice. And presentation of offer pursuant to our code of ethics. We are basically saying that all offers are to be presented to the seller, and that we're confirming that, yes, we've presented your offer to the seller. Very simple, straightforward stuff. Okay. We now sign here. So this is the buyer's brokerage firm. So that's the buyer's broker, obviously. So they're going to put in the firm, ABC Real Estate, the license number for ABC Real Estate, by Sally Smith, agent of ABC Real Estate, Sally's license number and a date. If you work as a team and there's two agents in your company that you guys work together, we now have a spot for 2 agents to execute. Mailing address. If more than one agent is from the same firms, let's use Paul and Stephanie, both work at Coldwell Banker Town and Country. They work at the same company. If they're both signing, then they're going to use form AAA, additional agent acknowledgement. Let's suppose that Paul works at Coldwell Banker Town and Country, but is doing a deal with Sally, who works at Century 21 ABC. Okay. If that's the case, Paul signs, Sally signs, and then you use more than one brokerage firm represents the buyer. additional broker acknowledgement, CAR form ABA. So that would say Paul represents the buyer, works at Coldwell Banker Town and Country. Sally also represents the buyer. She works at Century 21. Okay. This can be done. It's very unusual. If you guys ever find yourself in this situation, you need to reach out to Drew or Drake or Paul or myself. Let's talk about it. It can create confusion. It can certainly create some legal consequences. Who's maintaining the file? Or both offices maintaining the file? Why do we have two different companies representing the buyer? And generally where this comes from, it comes from a referral situation. Someone will refer an agent, or excuse me, refer a buyer to you. They work at Century 21, you work at Coldwell Banker, but they don't really want to let them go. Okay. Be careful with those guys. It can be done. It's certainly legal. We've got the documentation for it, but be very, very careful. I don't like it, to be honest with you. I don't like it at all. If you're going to give me a referral and you're from a different company, give me the referral. I'll pay you your 30% or whatever you want, but we're not going to put you on the contract. And frankly, just from an exposure, from a legal standpoint, oh my gosh, it just sounds like a nightmare. It's hard enough to have one company get sued. Now you got two different companies, two different brokers, two different policies, two different managers. Now you're sitting in front of arbitrations and your interests may not be aligned. Next thing you know, you have two different brokers that represent the same client that said, well, I didn't do that. Well, no, but Sally did that. Sally at Century 21 did that. Coldwell Banker would never do that. Oh my God, what a nightmare that would be. But it can be done. Just be super careful. Designated electronic delivery. So how can I receive delivery of acceptance, et cetera, et cetera? Sure. Email it to me, text it to me, or whatever the alternative is. Send it to me, DM me on Instagram. Okay. So again, we live in a different world. So delivery of acceptance, rejection, or whatever, that's where you would, and by the way, I'm assuming all of you guys are accepting delivery via email. But you got to be careful with that, by the way, because delivery via email means it was delivered to you. Doesn't necessarily mean you open that email. So we just had this happen on one of Celia's deals. I think it was last summer. And there was, without getting into the details, there was a question as to whether the offer had been delivered and conveyed acceptance. And our position was no, your offer, not only was it not accepted, your offer was rejected. We have an email and a text message saying it would, and a voicemail saying your offer is rejected. You simultaneously are sending an email that says we're accepting it. And we literally went to the date and timestamp of when that email was, and it was within the minutes. Okay, it was within minutes. And the good thing for us is we were 2 minutes before the email that came in with the acceptance. So anyway, how are we going to do that? This is the standard these days. Selling broker's firm, or excuse me, buyer's broker represents the buyer. Seller's broker is the seller's broker, the listing agent. Same information here, same exact options. Not going to go through them again. So again, you could have multiple brokers representing the other party on this as well. And escrow acknowledgement. Again, the original intent of this was the escrow was going to acknowledge that this was going to be a set of our escrow instructions. Now all that this says is, hey, escrow holders received a copy of it. Yep, I got the deposit. This is going to be our escrow number. This is going to be your information, and et cetera, et cetera. They do need to disclose how are they regulated. Are they corporate? Are they insurance? Or are they DRE? It's important for a variety of reasons. This is kind of the standard that, the independent corporate escrows is the Department of Financial Protection and Innovation. Department of Insurance this would be like First American Title or Orange Coast Title. They're regulated by the Department of Insurance. They do their escrows under the Department of Insurance. Our escrow, as we currently are constituted, are regulated by the Department of Real Estate. And okay, now we're done. And the very last item on the bottom of page 16 is this kind of goes hand in hand with what I just asked Drew. Hey, are you sending over the, hey, your offer has been rejected confirmation? This kind of goes hand in hand with the same thing. Are you sending over, hey, your offer has been presented confirmation? I'm going to suggest that 99% of the time, the listing agent is not signing this and sending it over unless the buyer's agent is asking them. So the presentation of offer says this is the agent. So this would be the listing agent. It could be the seller, but it could be Lance or Drew or our seller seller's brokerage firm presented offer to the seller on February 10th, whatever it happens to be. If you're getting a buyer's agent to send you this, they are ever so politely suggesting that you'd never presented their offer, and they want proof that you presented their offer because they think you tried to double end it or whatever it happens to be. Again, if you get asked, send it, okay? But generally speaking, they don't ask, and we're not taking the extra time to send these out. Totally up to you. Buyers and sellers initial, and guess what? Boom, we made it to the bottom of the RPA. So congratulations. It only took us 97 hours to get here, but so contract is over. So, however, as you guys know, and this says time for a break. We're not breaking. Let me get rid of that. Hold on just a second. We're going to use every minute we have here today. So where am I? Page 166. Oh, you know what? We might have to break. We might have to break because I don't think I actually, you know what? I'm going to do what I don't want to do, but I'm going to do it anyway because we need every single minute we have. So let's do something here. I'm going to go back. I don't have the rest of the contract here. On the Canva, I only loaded up to page 16. So let's go here. We're going to go a little off the grid here. So on slide 1, okay, on slide 1, we have the PDF material for this course. So let's click on that. So these are all the corresponding PDFs. I believe, oh no, it doesn't, maybe I don't have it. Hold on just a minute. I thought Austin had loaded. Bear with me. Oh no, we do have it. Okay, so this is where we just stopped. Okay, my Canva stops here on the bottom of page 16. So what I'll do is we're going to keep going. I'm going to use this PDF as my guide here. This is how we used to do it when Norm was doing Contract College. I thought I'd made it a little bit cleaner, but we'll take the next 8 minutes and we're going to continue on the package for what comes next. Well, what comes next is when after you get to the bottom of page 16, we go to the buyer's investigation advisory. So what are we doing here? Buyer signs the RPA. Buyer now has the ability to say, okay, well, what else do I need to know? Just like we have the seller's advisory, we have the buyer's advisory. So what do we got here? Buyer, it's important for you to investigate the property. Do your inspections, do your due diligence, go down to the city, go down into the county, go check out the schools, go to the police department, do all of those things that you may think are important. Check the Megan's Law database, all that sort of stuff, okay? Broker's obligations, paragraph 2. And this is one thing, this is why the class does tend to go a little bit quicker from this point forward, because there are so much repetition. So this is one of the things about, for those of you that are like coming in the middle of the class, and I say, hey, come in whenever you want. There's going to be a lot of things that are going to happen from this point forward till we get to the end of the class. I'm going to say, we already talked about that. We talked about that on day 3. That was in the listing agreement. Hey, we talked about that on session 4. That was in the RPA. Hey, we talked about that. That was in the transfer disclosure statement. So the repetition becomes extreme from this point forward. So again, broker's obligations. Have we already said this before? We don't have experts. We're not experts on taxes. We're not experts on termites. We're not experts on legal stuff. So just so you know. You are strongly advised to investigate the condition and suitability. Again, we're going to talk about this over and over in the contract. We have totally separate disclosures to talk about the condition of the property, the system of the property, the components, the heating and the plumbing. This is going to be covered ad nauseum. So again, buyers, be prepared. We go through the entire square footage and boundary addendum. So yes, if that's important to you, be prepared for that, because you're gonna have an addendum later on that you're going to sign that says this is what the square footage of the property is, and this is where we found the square footage of the property. You know, we got it from the county records, we got it from the builder, we got it from the seller, we got it from the appraiser. Wood destroying pest. Are you concerned about termites? Which, by the way, you'll notice nowhere in here does it say termites. Wood destroying pests in our vernacular is termites. Okay. If you're up in the mountains, they don't really have a whole lot of termites up in the mountains, but they have carpenter ants, and carpenter ants are worse than termites. If you live in Palm Springs, you have subterranean termites, the ones that live in the ground. You very rarely, if ever, will see a tent, the old termite tent on top of a property in Palm Springs. Dry wood termites get tented. They don't live down there. If you live at the beach, drywood termites love the beach, okay? You don't have nearly as many subterranean termites, you have more drywood termites, the type of tenting. So again, there's little type of things that as you gain experience in this business, you'll know, but are you concerned about? And it's not, and by the way, wood destroying pests, I mentioned termites, I mentioned carpenter ants, fungus, and dry rot. You'll have, most of you guys will have problems with fungus and dry rot more so than you'll have with termites. Drake's at home right now, tearing down his patio cover. The thing is actually loaded with everything, but it's most of what's killing his patio cover right now is dry rot, which is basically a fungus eating the wood. Is the soil stable? Is it settling? Is it cracking? What's it doing? Are you going to have a problem with your house slipping down the hill? Can I get water to my house? Can I get a well? We have separate disclosures on all of these. We will go through these ad nauseum. Environmental hazards. We're going to go through an entire NHD. So we're going to, again, this is why contract college is 10, 11, 12 weeks. Every single one of these we will go through in detail. Buyers, be prepared to know about earthquakes and flooding. We have a full disclosure on that, part of the NHD. Fire hazards, other insurance. We're going to go through this as well, ad nauseum, an entire section of that. Building permit, zoning, governmental. Yes, additional disclosures, part of the SPQ and part of the TDS. And, was the property built with permits? Is it zoned to do the existing use of the property, whatever it happens to be? Government retrofits and requirements. We go through this. Oh my gosh, this is all we're going to talk about for the next 4 weeks or so. Rental property restrictions. Is the property a rental? If so, are there restrictions? This used to just apply to the rent control areas. Now the entire state of California basically is within a rent control area. Now going back to January of 2020, for example, you can't raise the rent more than 5% plus the CPI, not to exceed an additional 5%. That is a rental property restriction. Maximum rent that could be increased is up to 10% underneath the rules that apply. But there's all sorts of other things. How many people can be in the property? Does it have window bars on it? All these little things. And again, I just find it so interesting, things that they add and they omit. Why did they think it was important to put things about deadbolts and locks? Because there's a gazillion other things in here that they could have referred to. Security and safety. Okay, so is the property safe? Do we have alarms on it? Are there barriers? Are there latching mechanism? My folks have a house down at the Salton Sea. It's got those fire bars on there. Those fire bars are completely 100% illegal. Why are they illegal? Because if you're on the inside and there's a fire, there's no release mechanism. You're stuck. You basically have built yourself a prison. You're not getting out of that house. So if and when I ever sell that house, or my folks ever sell that house, we have to disclose that those bars are safety hazard because they do not have that internal safety mechanism to release them. The neighborhood, the area, am I happy with the schools? Am I happy with the crime? Am I happy with the policing? Am I happy with whatever? The neighborhood's great, but I don't like kids that play drums, and the neighbor across the street plays the drums. So all of these things will need to be addressed as part of the buyer's advisory. Fair Appraisal Act addendum. Okay, so I may be confused. Is this part of the listing agreement? If it is, we already covered it. I think it is. Anybody know whether this form is part of the listing agreement? I think that it is. Let me skip ahead here for a minute because we're pushing right up. Yeah. Okay. These last couple of documents are also part of the listing agreement. So I'm not going to go through these again. We already went through these when we did the listing agreement. So the Fair Appraisal Act, basically saying the property has to appraise at the agreed upon value. Otherwise, we have to have a different discussion. The California Consumer Privacy Act, exact same form that we put in front of the buyer, in front of the seller when we did the listing agreement. So we have to comply with Civil Code Section 1798.100, and we have to make sure we're protecting, in this case, the buyer's information, and we're not loosely throwing that around. Okay, so That's great. So took 8 minutes. We got to finish the additional documentation that was part of the RPA. So we finished the listing agreement and all of the extra stuff. We finished the RPA and all of the extra stuff. So next week, we're going to jump in. I mentioned to you guys, I want to go through these buyer's representation forms first. So we'll take probably the first 20 to 30 minutes next week, and we'll go through those buyers broker agreements. And then we're going to start jumping into all of the disclosures. And we're going to just start knocking them out and taking names and kicking butt. So I don't see anybody. Oh, Alex, you're unmuted. What do you got?
Oh, well, yesterday I went to the MLS committee meeting and they were talking about like 24 new forms being added to like the site. Are we going to go over any of that, or
Yes.
did they talk about that any last
Yeah.
week?
Yeah, this is the deal. I don't believe that what they're referring to is twice a year, normally in December, which just passed, and generally in June, CAR comes out with forms revisions and some new forms. I don't believe there's actually 24 new forms that are going to impact what we're doing. There's probably going to be revisions, and we will absolutely deal with those. Having said that, those revisions, assuming they all happen, are not even going to be published until probably June. So this is one reason, again, I feel like I'm channeling Norm. This is one reason why everybody needs to kind of get into contract college once a year, or at least go through, hey, I got this dialed in, but I better know what the revisions are, because some of these revisions are huge. So the short answer, Alex, is yes, we will go through the ones that apply. A lot of the forms I think that they were referring to in MLS have to do with property management. We will cover some property management stuff here, but not like full-blown property management on this one. We're really going to stick to residential purchase and sale agreements here. But the short answer is yes. And as always, if you guys have a question, bring it here. We'll deal with them. So, okay, we're running a little bit late. My audience is starting to fall. So Javier, you'll close.
Yeah, quick question. Lance, if two different brokerages represent the seller, should I include that form ABA, the additional broker?
100%. Not only can you must.
Must,
So
okay.
yeah, that additional broker addendum or additional broker agreement, whenever you have multiple brokerages representing the buyer or the seller, you will check that box underneath the signatures for the agent side. So it's going to be Javier, Coldwell Banker Town and Country, Sally Smith at Sally Smith Realty. You will check that ABA, additional broker addendum, and then they will sign. That is required if you have that. And quite honestly, if you're doing it within the same office, so if Javier and I are working on the same deal and I'm going to sign the form, Javier is going to sign the form, we need to use AAA, additional agent addendum, that in effect now says the owner or the buyer is working with two agents at Coldwell Banker Town and Country, Javier and Lance. So both of those are required if you're going to have agents work with those clients. This is a big thing on teams. So if you're a team and you have 3 or 4 people that are working on your stuff, then you might have 3 or 4 agents that are on there. So, okay. All right, guys. Good job. You're sticking in. So contract portion we got. Now we're going to hit disclosures next week. Have a great one. Go sell something, and we will talk to you later. Bye-bye.